I'm Matt Guichard. In this episode of No Holds Barred, we're going to talk about concealed carry laws in the state of California. Myths and facts. So I will say, in spite of what you may have heard, it's not that easy to get a concealed carry permit in the state of California. Particularly in Bay Area counties, in fact, it's very difficult. I will say the Bruin case, which is the United States Supreme Court case recently, that seemed to take away a certain amount of discretion, and that case happened in the state of New York. What was actually happening there, and the same as in California, was the sheriffs or the authorities who could issue concealed carry permits in that state of New York had broad discretion to deny to people applying. And it depended on the county that it was in. It depended on the jurisdiction, say whether it was a police chief. And it counted on whether or not that particular authority figure felt that there was good cause to issue that permit. There's been a great deal of concern recently in the state of California and throughout the country about this concealed carry rule that our Supreme Court recently issued in the Bruin case, B-R-U-E-N case. And essentially what the Supreme Court said was taking away the kinds of discretion that licensing authorities, and in most cases, say sheriffs or police chiefs, had in denying permits to people who were otherwise responsible enough and otherwise legally could obtain a concealed carry permit. And what does that mean? Well, let's say in practical effect, somebody wants a concealed carry permit. They otherwise are in a position where they could qualify. That means they have no felony convictions, they've never been arrested. There are a number of reasons why a court might want to, or a licensing authority might say that a person is not eligible. But what the Supreme Court said, if a person is eligible for whatever rules that there are in a certain state, that licensing authority, whether it's a police chief or a sheriff, cannot deny them simply because in that licensing authority's opinion, there isn't good cause. Well, what would be good cause? Well, somebody would say, hey, I have an immigration law practice and mostly we get paid in cash, and I go to the bank a great deal, and I need to carry for protection. I've got a cuckoo neighbor who's got a lot of guns and he kind of scares me, and I want to have my own gun just in case he comes over to my property. Or for whatever reason. I have a security company and none of my people are actually licensed to carry weapons, but when I go around late at night, I want to be able have a weapon and be legally able to carry it. And those are reasons that people would say there are good cause reasons. In the state of California, particularly in the Bay Area, licensing authorities, and they're typically sheriffs, have been very strict about who they will allow to have a concealed carry. And the good cause requirements have to rise to a certain level of, look, I'm a former prosecutor, whatever reason I've been threatened a number of times. In my line of work, I regularly get threatened. I'm a Superior Court judge. I deal with all kinds of issues, and I think it's important. And in many cases, those people can get a concealed carry permit, but only if they otherwise qualify. What I do want to do is mention that based on that Bruin case that the California Attorney General Bonta recently advised in a written document to sheriffs and police chiefs in the state, and the document says to them, they may no longer require a demonstration of good cause in order to obtain a concealed carry permit. And so what does that mean? That means that asking them what the reason is why they want one. And if somebody says, I want it for self-defense, and they otherwise qualify, then at least according to this document that went out to police chiefs and sheriffs, they need to take that into account in issuing. I will tell you that I don't believe that there's going to be a great rush at this point for concealed carry permits being granted, because they are only to people who otherwise are qualified. And let's just talk about California Penal Code section, and I'm going to read a couple of sections for you. California Penal Code sections 26150 and 26155 provide that a sheriff of a county or the chief or other head of a municipal police department of any city or city and county may issue a license to carry a pistol, revolver, or other firearm capable of being concealed upon the person, and we call it a CCW license. Penal Code section 26175 requires the Attorney General to prescribe a statewide standard application form for a CCW license. So let's talk about that. It's talking about the Attorney General giving a standard. It's the same form, it's the same requirements, and that's a big requirement. And then it also talks about specifically a pistol, a revolver, or other firearm capable of being concealed. So this concealed carry does not apply to rifles, assault weapons, anything such as that. It is something that is concealed on the person. So in the state of California in general, people are not allowed to carry to what we call open carry, and that is carry a handgun on their hip in a holster, even if it is unloaded. I recall not too long ago there were people that were challenging the rules and going into, let's say, a Starbucks, a number of people, and sitting and having coffee with unloaded handguns on their hips. That is a violation of the law now. You cannot do that, whether the gun is loaded or unloaded. And concealed carry does not allow a person to carry a handgun openly, loaded or unloaded. Concealed carry specifically is it is concealed on your person. People do not know that you're carrying it, and there's a purpose for that. There's a reason for that. And that's part of what the law is, and it's very important to understand. The question is, and I'll read this document that's put out by the California Department of Justice Bureau of Firearms, and it talks about the standard and initial application or renewal for a license to carry a concealed weapon. The licensing authority specified in Penal Code section 26150 and 26155 may issue a license to persons who are of good moral character, who have completed a course of training, and where good cause exists for the issuance of that CCW license. And you would expect that Attorney General Bonta sent out saying that the good cause exists is something that can no longer be taken into account. However, they must be a person of good moral character, and they must have completed a course of training. So, a concealed license may be issued in either of the following formats: a license to carry a concealed pistol, revolver, or other firearm capable of being concealed upon the person, or, interestingly enough, and this doesn't take in the Bay Area, where the population of the county is less than 200,000 persons, according to the most recent federal decennial census, a license to carry loaded and exposed in the county a pistol, revolver, or other firearm capable of being concealed upon the person. So that seems to say that in those smaller counties, somebody can actually carry that weapon if they have that permit. Perhaps more importantly right now, I want to read to you from California law about firearms prohibiting categories. And there are a number of them, but I think it's important that you hear about them in this episode. any person who is convicted of a felony or other offense enumerated in certain penal code sections, any person who is ordered to not possess firearms as a condition of probation, any person who is convicted of a misdemeanor listed in Penal Code Section 29805, any person who is adjudged a ward of the juvenile court, any person who is subject to a temporary restraining order or an injunction issued pursuant to a civil code or civil procedure section, any person who is found by a court to be a danger to himself or others because of mental illness, any person who is found by a court to be mentally incompetent, any person who is found by a court to be not guilty by reason of insanity. And I could go on and on and on. And the reason why I read those is I would ask that anyone who's really interested can certainly research these issues and go on the Attorney General or State Department of Justice website and look at all of the categories. So perhaps the comfort and one of the myths is that just because the Supreme Court ruled in the Bruin case as it did about the good cause does not mean that everybody gets to go out and buy a gun, and anyone who wants to, nut cases, mental cases, people with felony convictions, no, none of those people are any more capable of obtaining a concealed carry permit in the state of California now than before. And so be comforted in the fact that if you were to apply for a concealed carry permit, you first of all have to purchase a gun. In order to purchase a gun in the state of California, you have to go to a gun store, review whatever gun you want to buy, pay for that gun, and then wait a minimum of a 10-day period in which there is a background done by the State Department of Justice. And that is a 10-day period of time. If you don't qualify, and I just read off just a few of the lists of prohibited categories, just a few of them. If any of those categories, and many more that I didn't read, apply, when you come back at the end of the 10-day period, you don't get to get that gun. You actually get some of your money back, but typically in gun shops, there may be some wording in the document that says for what they've gone through, they get to keep a certain portion of the purchase price of that weapon. But I do want to repeat that not everybody gets it. Now, something that is false, and I've often heard this, lawyers say that if you come back at the end of the 10-day period and the report has not come back from the State Department of Justice for whatever reason, they have to give you the gun. Absolutely false. That period can stretch out to 30 days or more, because no one is going to be able to get that weapon until the State Department of Justice has provided a report that says the person is capable and legally can possess that weapon. I'll say something else we have, and I've talked in another episode of 1203.4 about people clearing their records. And so under 1203.4 of the California Penal Code, where somebody has filed an application to have a felony reduced to a misdemeanor and then that misdemeanor dismissed, even though they've had that case dismissed, and even though that felony has been reduced legally to a misdemeanor and dismissed, they cannot, under the law, possess a weapon. That is one of the critical points in 1203.4. That so once a felony, unless you're found to be factually innocent, but otherwise, once a felony, always a felony, you cannot possess a firearm. It becomes even more interesting when we talk about these kinds of things, that if you have a roommate, for example, who has been convicted of a felony, there cannot be a weapon in that household. Not even a hunting rifle, nothing. So that if you have a friend who's been convicted of a felony, your hunting weapons, your weapons have to go somewhere else, or you have to go somewhere else. And that's kind of a critical point that we often think about. So what are the requirements? Let's get back to, you've applied, you have obtained a firearm, it's gone through the State Department of Justice, and they agree that there is no prohibition. You get your weapon. Prior to getting that weapon, you actually have to go through a test to determine whether or not you know what the rules are with respect to possessing a weapon. Once you get the weapon, you actually have to go through a process of showing that you know how to handle the weapon. Load it, unload it, handle it safely. That's all part of the requirement just for buying that weapon. With respect to the concealed carry, you then have to go through another process of being fingerprinted, making an application, which again, that goes to the State Department of Justice, where again, a second background check goes. On your concealed carry permit, in most jurisdictions, you're allowed no more than 2 that you can list. So we go back and say, well, you had to have purchased, if you want 2, you have to have purchased 2. You have to go through the same process of purchasing those 2. You have to show that you know how to handle them, and you have to go through a test so that you know how to handle and what are the rules. In the state of California, I'll just show there are documents that you can get from the State Attorney General's Office, Department of Insurance, a firearm safety certificate, and that is available to read all about firearm safety and how you should handle it. There's a California firearms law summary from the State Department of Justice, and you can get those. All of those are very important, and all of those, in many cases, are part of the process of applying for and getting a concealed carry permit. Let's go back again to that where I was saying, now you've picked up your weapon, you've applied, and the sheriff or authority in that particular jurisdiction will look at the application as to why you want to carry it and make a determination. I know there's been a slight softening in what is required with respect to good cause, but nevertheless, that is the authority of, let's say, the sheriff to say, I'm going to deny that person. But let's say the sheriff says, okay, you can receive a concealed carry permit. What does the person have to go through? They have to go through a significant training period and testing period. And that typically would happen, let's say, at a sheriff's range. So you're signed up, you don't get the permit yet, you have to go through a class, at least 4 hours, and in some jurisdictions, a full 8-hour class taught by somebody about all the issues as it relates to firearms, firearm safety, what the law is, talk about self-defense, stand your ground, all these various things that you have to learn. And then you have to take a test to ensure that you learned what was taught in that particular class. And then you actually have to go through what I call some proficiency training. And that is, you actually have to take, if you have 1 weapon or 2 that are subject to this concealed carry, you have to be able to fire those at a range under supervision and fire them during a certain time period. And you have to load and reload within a certain time period. And you have to hit a target within a certain range. All of that, if you don't hit within a certain range, you don't qualify. If you can't load it and unload properly and safely, you don't qualify. If you don't pass that test, you don't qualify. So there are a number of things that are important to know, just to let you know, and I want to repeat that everybody doesn't qualify, and everyone, all of your neighbors and all the people you know, don't necessarily qualify for concealed carry. We go then to issues as to what would happen if you get that concealed carry, which is only valid for 2 years, and then guess what? You have to go through the same process all over again after 2 years. The classes, the training, and all of that. If during the course of those 2 years you were, let's say, arrested for DUI, you'll lose your permit. If you're involved in any crime or any activity on this list of prohibitions, you lose that ability to have a permit. Part of the training talks about do not carry that weapon if you're drinking alcohol. The law talks about do not take that weapon into a business, which primarily a business is the sale of alcohol. So don't take it to bars, don't drink when you have it, don't pull it out when you've been drinking. All of those rules apply, and if you violate them and the licensing authority, particularly the local sheriff, finds out about them, you will lose that ability to have a concealed carry. If you brandish it, so Penal Code Section 417, and people sometimes you may have seen or heard that somebody's driving down the highway, there's a little bit of road rage incident, and somebody displays a weapon in a threatening fashion. That's a Penal Code Section 417, a brandishing a weapon. That will absolutely get you your violation and have you lose your concealed carry permit. So many, many reasons why. And since that Bruin case, that United States Supreme Court case, the state of California is passing legislation to further limit those who legally have a concealed carry, to keep it from being carried anywhere at schools, in courts, on public lands, in public parks, a number of other ways in which the concealed carry permit may be something prohibited in spite of the fact that you qualify and you have it. In certain areas, you can't take it. Now, we all know that you certainly can't carry it onto an airplane, and sometimes we hear that somebody's at the airport and going through security and, wait a minute, here's my concealed carry permit. With respect to that document, you get 2 little cards. One is the local, and one is one from the State Department of Justice that says that you have a valid concealed carry during a 2-year period of time. You must carry those documents with you at all times when you are in possession of that weapon. Now, unlike most people, somebody has a gun and they like to go to the range, they must carry that in their trunk or otherwise locked up, separate and apart from the ammunition. If you have a concealed carry permit, you do not have to do that. You can have your gun loaded in a secure place. However, even with a concealed carry permit, all the laws that relate to having it in your vehicle and your vehicle stolen because it's not properly concealed or secured is very important. So it's critically important to understand that just because someone has a concealed carry permit does not mean that they can act in any other fashion with respect to being unsafe. They need to secure that weapon. They need to ensure that within a vehicle it is secured. When kids are around, it is secured. At home, it is secured. That they're not drinking alcohol or any other prohibited activity related to that gun. I will say that, interestingly enough, there are some states that are permitless. That means, in fact, I think there are about 21 states in the United States in which you don't need a permit. And I think that's going to be changing over time. But for the time being, about 21 states, so a majority of states certainly have some kind of concealed carry rules on the books. California has reciprocity with about 15 other states, and that means that there are about 15 other states that recognize a California concealed carry permit if someone, for example, goes to one of those other states with their concealed carry. I will say best practices with respect to people who even have concealed carry, as I would say applies to anyone else, If there is a dangerous situation and the police need to be called, the very best practice is to dial 911 and let the police handle the matter. The only situation in which someone who has a concealed carry permit should exercise that right and pulling their weapon out to use is if their life or the life of another is in danger. So that's suffering death or great bodily injury. Don't be an officious intermeddler and think that I'm going to run across the street and try to stop that robbery or chase that hit-and-run car down. That's not what it's for. That's not smart. Don't do it. And if you absolutely believe that you have good cause, in spite of the fact that the courts have said that that's not a reason, but I want to say to you, that is a good reason for an individual to decide whether or not he or she wants to apply for a concealed carry permit. Think of that reason why you want it. Think of that reason why you think you need it, and be able to articulate that in the application. Thank you for watching this episode on concealed carry. Like and subscribe, and we look forward to seeing you on the next episode of No Holds Barred.